Text or something. Judge, I wasn't sure if you called me.
No, I didn't, not yet. Are you ready?
I'm ready because I have the competency report now.
Okay. Here is.
Will be on in about 2 minutes. Excuse me, Your Honor, did you want me to bring the father in?
Oh my goodness.
I'm sorry, what did you say?
The father of.
Oh, yeah, he does.
I'm sorry, it's Leah.
Colleen Sullivan is the mother to.
Family, celebrating 50 over your baby.
Attorney Roy, the prosecutor just tried to call you, Mr. Sawaki tried to call you, said it went to voicemail.
Yeah, Judge, I just tried returning the call, but it's not going through.
This is the court phone number, so you won't be able to call. He's gonna try.
I'll try again.
All right, hold on one second. I'm gonna have to unblock you.
Okay.
You should be good.
Attorney Barwell, are we waiting for Mr. Solomon to log on? I didn't hear you.
Yes, Judge.
Okay, all right, so we have his parents, present as well.
Right.
So we'll wait until he logs on.
Well, yeah, he's in the forensic center, and I don't know that he's gonna log on. He's not in the jail, he's in the forensic center.
Right. Okay, well, today, nothing, significant is going to happen. Do you want him present?
I mean,
Later today.
Jesus.
Okay.
Okay, well, while you're figuring out if you want him present, I'm gonna call another case. Let's handle Mr. Andre Barnes.
Good morning, Judge. We're ready on Andre Barnes.
Okay. This is case 2356192, the people of the state of Michigan versus Andre Barnes, who is defendant number 2 in charge with count 1, false pretenses, $20,000 or more, but less than $50,000. Also charged with count 2, motor vehicle code, intent to pass false title. Count 3, uttering and publishing a state warrant with the habitual offender fourth offense notice set for a probable cause conference. Today appearances.
That was walking CR438. You know, I made a moment with this cheaper thing. I think it might not be a 488.
Good morning, Your Honor. Scott Rourke appearing on behalf of Andre Barnes, who is present via Zoom, and we have no objection to the Zoom conference this morning.
Okay, Mr. Barnes, can you state your full name for the record, please?
Andre Daniel Barnes.
Judge, I spoke to the prosecutor about this case. We do.
Before you start, I think the prosecutor is trying to figure out if this is a specially assigned case before he does anything on the record.
Okay, if you want to pass on us, that's fine.
Sorry about that.
Attorney Lamb? Attorney Harris, the jail is getting ready to log on.
Okay. Now I'm ready on Mr. Barnes. Tyrell,
Okay.
he's gonna waive.
Are you ready to go back on the record on Mr. Andre Barnes? Did you find out?
We're working on
Still
it.
working on it. Attorney Barwell, do you want your client present for
Yeah,
the?
it's loud
Is
there.
he here?
Your Honor, I can waive his
Look up
present.
the
I
crowd.
think that what has to happen is, I think it's a year is the magic number, and the year is approaching. for
15
the
months.
treatment marker. Pardon?
I think it's 15 months.
Okay, so it's not approaching. I am extremely busy. I'm in court. I have a million cases. So I can't wait indefinitely. I'm in a courtroom right now. I just went into the little witness room. So can you call it? Thank you.
Yeah, I've been waiting for you to let me know you were ready without your client.
Yes, I'll waive his presence for this hearing.
Calling case 2158585, the people of the state of Michigan versus DeAndre Lamont Solomon, charged with 2 counts of assault with intent to murder, 2 counts of assault with intent to great bodily harm less than murder or by strangulation, 2 counts of assault with drug and felonious assault with habitual offender. Third offense notice set for a competency hearing today. Appearances.
That was Walker P 54828.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. DeAndre Solomon. Your Honor, I would waive his presence. He's in the forensic center under treatment. He's been there since July, I think it's 25th. I'm not sure of the day, but it's 2022. He's been there.
I have July 25th, 2022. Okay, and we've received a report dated May 23rd of this year stating that he remains incompetent to stand trial. Did the people and Attorney Barnwell, did you all both receive that report?
Yes, Your Honor.
I have seen that report, yes.
Okay. So at this point, the recommendation is to continue treatment, and as you said, the magic number is 15 months that we have to get to for anything to change. Let me get an exact.
I'm wondering if the court can send like an email to the forensic center about his the Zoom. Like I had a forensic center up north have my client on Zoom, not his client, but a different client. But I've not experienced that with the Ypsilanti Forensic Center. But I'm wondering if, because he calls me quite a bit, but the conversations reflect what's in the report. I mean, he's better, but
Are you saying for next time for him to be on Zoom?
yeah, if that's possible. I don't know. I know they're a bigger forensic center than the one up north. So
Okay, so I'll put that in notes. Let's come back on October 26th.
October 26th.
That's gonna be 15 months.
Okay, October 26th at 8:30, Judge. Correct?
8:30, that's fine.
Okay. Thank you.
You're welcome.
Thank you. Have a good day. Have a good day, Miss Solomons. His mom is here. Okay.
And his dad-
I'm ready on Kristen Gould.
Okay, who's the gentleman, Wayne County Jail? Can you state your name, please?
Good morning, Your Honor. Terrell Barnes.
Good morning, sir. Attorney Mays, can I have you checked in? Good morning. This is the people of the state of Michigan versus Terrell Tyrone Barnes, 2355950. Mr. Barnes, Mr. Terrell Barnes is charged with count 1, police officer assaulting, resisting, and obstructing, as well as count 2, same charges, set for a probable cause conference today. Appearance.
Edmonds, Milwaukee, P 54828, here on behalf of the people.
And Judge, good morning. Lyle Harris for Mr. Barnes. State your name, sir.
Terrell Barnes.
Judge, we're here for a pre-exam. I've discussed the matter with my client. At this time, he stands ready to waive his exam.
Is that correct, Mr. Barnes?
Yes, ma'am.
Okay, I'm going to ask you a series of questions. If you don't understand my question, you can't hear me, please let, okay?
Yes.
And before I begin, Mr. Walken, is there an objection to the waiver?
No objection, Your Honor.
Okay. Mr. Terrell Barnes, is it your wish to waive your preliminary exam today?
Yes.
You understand that you have a statutory right to a preliminary exam?
Yes.
And that if you were to demand that exam, the people would have to show at the probable cause standard, which is a much lower standard in criminal law, but still a standard, that those 2 charges I read off were committed in the city of Detroit and that you probably committed those crimes. You understand that?
Yes.
And thereby waiving your exam today, that means that people do not have to prove anything as a probable cause standard. Understood?
Yes.
You also understand that you are not giving up your right to trial?
Yes.
And knowing that information, do you still wish to waive your exam?
Yes, ma'am.
Did anyone force you or threaten you to waive your exam?
No.
Did anyone promise you anything?
No.
That I find your waiver to be freely, understandingly, and voluntarily given. Since you are in custody, your arraignment on the information date will be exactly 1 week from today. It will be June 8th at 9:00 a.m. Frank Murphy Hall of Justice. Mr. Terrell Barnes, do I have your permission to sign your name on the waiver form since you are remote today?
Okay.
Is that a yes?
Yes.
Okay. And as well as Attorney Harris, do I have your permission?
Sure. Yes, of course, Judge.
Okay. Anything else from the party?
No, Your Honor.
No, Judge, thank you.
You're all set, Mr. Barnes, Terrell Barnes. You're all set for today.
All right, Mr. Barnes, I'll talk to you later. Thank you, Judge.
Okay.
Have a good one.
You too.
This is Mark Magidson checking in on Mr. Steve Evans.
Good morning. I have you checked in. I got 1 case in front of you and I can call yours.
Thank you.
Any word on the special prosecutor? Other bars? Attorney Margolis.
Yes, Judge, I'm ready.
Okay. This is case 2356906, the people of the state of Michigan versus Kristen Marie Gold. Charged with 1 count of controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Count 2, controlled substances, possession, or another narcotic less than 25 grams. Set for a probable cause conference today. Appearances?
Edmonds, Milwaukee, P 54828, here on behalf of the people.
Elliot Margolis, P 28078, on behalf of Kristen Gould, Judge.
And have you been in contact with your client?
I have not. I wrote her a letter after the last PCC last week and asked her to contact me immediately. The phone number that I had is not a good phone number. And I put that all in the letter and she has failed to contact me.
Okay. So we can do two things. I can either enter capias, it'll be a personal since she does not have a capias history as of yet, or I can set it for an exam date and you can continue to look for your client.
Pardon me?
So two options, I can enter a capias today, it'll be a personal capias since she does not have a capias history as of yet, or set an exam date and you can continue to look for your client.
I don't think she's going to be contacting me, Judge. I wrote her a letter and I have no way of contacting her, and she has not responded to my letter.
Mr. Walker.
People would ask for a KPS, Your Honor.
Okay, it'll be a $1,000 personal capias, and if you can find her, you can call the court, we can schedule a walk-in.
Thank you, Judge. Appreciate it. Bye-bye.
Bye. Mr. Crowley, we're getting your attorney, let your case can be called. Attorney Madison. Ready on Steve Evans.
Morning, Judge.
Okay, this is the people of the state of Michigan versus Steve Evans, case 2356313. Mr. Evans is charged with count 1, malicious destruction of fire or police property. Set for a probable cause conference.
That was the walking CR438 today, people, we have people.
Good morning, Your Honor. Mark Magidson, P number 25581 on behalf of Mr. Evans. I don't see him in on the Zoom hearing here. I have not been able to reach him. I don't know if he's in the waiting room or not.
There's no one in the waiting room, and he hasn't checked in.
Right, so we've called, I have 2 numbers for him plus an email. We've been trying to reach out to him, and we have been unsuccessful. We could do one of 2 things. We could either set this for an exam in hopes I find him, or we can schedule another PCC, or you can take other action.
Okay, I'll set the exam date because it was just arranged, so he's somewhere, and hopefully we can find him, and then we'll go from there.
I'm sorry, I didn't hear you, Judge. What do you intend to do?
I'll send the exam date. Unless you don't want an exam date.
Oh, yeah, let's get an exam date.
Okay. Does June 12th work for you?
June 12th. Yeah, that should work.
Okay, I have 9, 9:30, or 10 o'clock open.
9 o'clock would be great.
Okay, June 12th at 9 o'clock.
Thank you, Judge.
Well, Attorney Lamb.
Good morning, Your Honor.
Good morning, how are you?
I'm doing well. How are you?
Pretty good. You ready for your case to be called, or are you waiting for your client?
Please, I would ask for it to be called.
Okay. This is case 23571, the people of the state of Michigan versus Leuven Benny Thomas Boyd, charged with 1 count of assault with a dangerous weapon, felonious assault, set for a probable cause conference today. Appearances.
That was the walking P5482, appearing on behalf of people.
Good morning, Your Honor. My name is Michael Lamb, P number 79816. I'm appearing on behalf of Leuven Boyd. I will respectfully request that his appearance be waived at this time.
I will waive his appearance. You have discovery?
Thank you, Your Honor. And at this time, we do. I've received paper discovery. We are demanding the examination.
If they don't have set here for June 8th, does that day work? I have 9, 9:30, or 10 o'clock.
So if I could get maybe later in the morning, that would work on June 8th or some other day.
How about 11?
11 a.m. would be perfect.
Okay. So June
Thank you.
at 11 a.m.
Thank you, Your Honor.
Anything else?
Nothing at this time.
Okay, have a good one.
You do the same.
We just have Crowley and Andre Barnes.
Judge, I spoke with the special prosecutor on Andre Barnes and we're ready.
Okay. Are you going to be on the record?
Roxanne.
Yeah, but it's more than likely it's not. Okay, you go record. Thank you.
All right.
Attorney Rourke, are you ready back on your client case?
Yes, Your Honor.
Okay. This is a recall of the people of the state of Michigan versus Andre Barnes appearances.
Good morning, Honor. Daniela Parrish on behalf of the people, 285495, standing in for APA Blackburn with Tattoo Unit.
And good morning, Your Honor. Scott Rourke appearing on behalf of Andre Barnes, who is present via Zoom. We have no objection to the Zoom conference this morning.
Mr. Barnes, can you put your appearance back on the record?
I'm sorry, Your Honor. Could you repeat it, please?
Sure, just state your name again.
Andre Barnes.
Thank you. Okay, so there is a special prosecutor on the case, and Ms. Parrish, that prosecutor is not available today, correct?
Correct, Your Honor. This was not in our PDK system, so they had no notification that this case was up. I have emailed them to confirm, but I did speak to defense counsel on the telephone, and they indicated that they need an adjournment anyways, which the people will not object to.
Judge, everything prosecution just said is correct. If the court would be willing to, we would ask for a 30-day adjournment. There is a case pending up at circuit that we are looking to get resolved prior to dealing with this case. Or at a minimum, we would be asking for a 2-week adjournment, Your Honor.
So I can't just give a 30-day adjournment because of circuit court case. I have time frames I have to stick to as well. If it's not regarding this voluminous discovery or some specific reason for good cause to go outside of the time frame.
And Judge, I would indicate that we did just get discovery in this matter. There does appear to be video evidence that we are also going to be requesting. So there is a little bit of an issue with discovery, but nothing that seems too substantial.
So let's come back. You come back next week for another PCC? Give you time to look at the discovery.
I could do the 8th, Your Honor.
All right, June 8th at 8:30.
June 8th at 8:30. We'll see you then.
Okay, Mr. Barnes, you can still log on Zoom for this case for the 8th. You do not have to be in person as of yet, okay?
Yes, Your Honor.
Okay, anything else for you, the party?
Nothing for the people, Your Honor.
No, Judge.
Okay. You're all set.
Thank you, Your Honor.
Thank you, Your Honor.
You have a good day. Attorney Diallo, good morning.
Good morning. How are you?
I'm fine. How are you doing?
I'm good. Is that Mr. Polk's client, Mr. Crowley?
It is.
Okay, can I go in a breakout room with him for a few seconds and then come back so I can introduce myself?
Sure.
Thank you.
Crowley, I'm going to put you to a breakout room with Attorney Diallo. Your device to be unmuted to speak to her.
Judge, unfortunately, he hung up by accident. He was trying to unmute.
Okay. So you didn't talk to him, did you?
No, he was trying to, I'm sorry, he was trying to take the mute off and some kind of way he just disconnected. But I see what it is. I can arrange, I'm sorry, I can do the PCC and then I'll talk to him.
He's back.
Okay.
Check in.
Mr.
Oh,
Yeah.
what was the date?
It's actually Diallo.
Oh, it's Mr. Diallo on vacation. So we're done with all the PCCs.
I do believe so. Yes. We just waiting on the tenant, like you said, but
Sure, we're just waiting on the thing.
so we know it.
Yeah.
Thank you.
You're welcome.
you speak to him at all?
Oh, no, I spoke to him this time. We're ready. I think
Okay.
did some. Yeah.
Logged off again. Okay, we're gonna waive his presence. This is people of the state of Virginia versus Randall Crowley, 25838H. Mr. Crowley is charged with 1 count of assault with a dangerous weapon, felonious assault with a habitual offender court. The offense notice set for a probable cause conference and appearances.
Edwin Sawaki, P54828, appearing on behalf of the people.
Judge, good morning to you and your staff. Lillian Diallo, P52036, on behalf of Mr. Randall Crawley, who I did have an opportunity to speak with, and I'm standing in for the attorney of record, Larry Polk.
And we have the county jailman. Mr. Crowley, unmute the device and state your name, please.
Hello,
Yes, state your name.
Randall Bernard Crowley.
Okay, you had the opportunity to speak to Attorney Diallo today.
Yeah, it just cut off on me. Zoom meeting cut off on me.
Okay, are you giving her permission to stand in for your attorney, Attorney Polk?
Yep.
Okay. You know if Attorney Polk has discovery?
Judge, I'm not aware. I'm looking right now. I'm trying to see if I can access the email. If I may inquire of the prosecutor if they sent the discovery over.
No, we have not, due to the fact that we haven't any discovery at this time. This was a conversion over to PPK, and I'm in the process of trying to track down the actual physical file, hoping that it is still alive.
I'm sorry, how old is the case?
22.
Oh. So what do we do? Set it for an exam, dismiss it, what?
Yeah, we can set up an exam and motion can be made on that day if there's no discovery.
Okay. Okay, so we'll keep the preliminary exam date that we do have in this case, and I believe it's June the 8th, if I'm not mistaken.
Yes, can you 11?
Yes, June the 8th at 11. I'll send it over right now.
Okay, 11 to 5.
All right. Me and Mr. Crawley talked about his bond and how there was already a redetermination, so we stand. Don't we, Mr. Crawley, that your bond is gonna stay where it is for right now?
$20,000 personal.
Yeah, I have 20,000 personal.
But something else is holding him though, I think.
A tether. I'm waiting.
Okay, we'll go with that, Judge, but June the 8th is a great day for Mr. Polk at 11.
Okay, so Mr. Crowley, your exam has been set for June 8th at 11 o'clock to 36th District Court. If you are released by the Wayne County Jail with a tether, by that time you are to show up in person on your own, June 8th, 11 o'clock a.m., 36th District Court. You understand?
All right.
Okay, you have a good day.
Is that a yes? You do understand the judge?
Yeah, I gotta be there June 8th.
Right, and you know, we got to talk to the judge a certain way. So you say yes, ma'am, or yes, judge, okay? You understand, Mr. Crowley? Now, okay, what you gonna say to the judge? You're gonna say yes, ma'am, right?
Yes, ma'am.
And thank you so much. Judge, you and your staff have a great day.
You all as well. Thank you. You're all set, Mr. Crowley. All of that. Okay, we're on the record. This is case 2355470, the people of the state of Michigan versus Makai Gilmer. Charged with count one, larceny from a motor vehicle, count two, controlled substances, possession cocaine, heroin, or another narcotic less than 25 grams set for exam today. Karen?
Good morning, Your Honor. Daniela Parrish on behalf of the people, P 85495.
Good morning, Your Honor. Stephanie Carson on behalf of Makai Gilmer, who was present in court, P 57016.
Mr. Gilmer, can you state your full name for the record? Okay, Attorney Carson.
Thank you, Your Honor. My client is aware of his right to a preliminary examination, and he knows that the people would have to show probable cause to believe a crime was committed in the city of Detroit, and probable cause exists to charge him with that. My client wishes to waive his exam because this case has been part of a prior plea agreement with the prosecutor, where once he's sentenced on that matter, this case will be dismissed. I just confirmed that with APA Sarah Leon. So he understands that he's waiving, but the outcome should be this matter is dismissed as long as he shows up for sentencing. Is that correct, sir? Speak up, please.
Yes, ma'am.
Okay, thank you. Give a word for me. Did anyone force you or threaten you to waive your exam today?
No.
And outside of the promise that your attorney just stated on the record, did anyone promise you anything else to waive your exam?
No.
Okay, I find your waivers to be freely, understandingly, and voluntarily given. Since you are out of custody, you'll be bound over to Third Circuit Court, Frank Murphy Hall of Justice for an arraignment on the information dated June 15th at 9:00 a.m. And I have a form here if everyone's fine. Outside of that, is there anything else we need to go on record?
Well, thank you, Your Honor.
All right, well said. You're on the record. This is the people of the state of Michigan versus Andrew Quanted Love. 2355618. Mr. Love is charged with one count of weapons carrying concealed with an habitual offender second offense notice set for exam day. Appearances.
Edwin Sawachi, P5488, here on behalf of the people.
Good morning, Judge Jeff Perlman, PO 517, appearing on behalf of Andrew Love.
Mr. Love, please state your full name for the record, please.
Andrew Quanted as well.
Good morning. Is everyone ready to move forward and proceed?
Yes, Your Honor.
Yes, Judge.
Any preliminary matters?
None from the people.
None from the defense.
If there's anyone on YouTube or Zoom who may be a witness on this case, now is your time to log off. Same for the courtroom. Okay, who's going first witness?
Officer Jalen Bobson. That's MABSON.
Report first, then I'll swear you. Swear you first, please.
LA. MAB. SO. Nancy.
Okay, raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Okay, well, who's in the front here, so make sure you speak up in the microphone. This is the one.
Thank you, Your Honor. Officer, could you state your name and occupation for the record, please?
Jalen from Madison, work for the Detroit Police Department, 8th Precinct,
How long have you been with that agency?
early December 2019.
And were you on duty on February 16th, 2023?
Yes,
And were you on duty in the area of Nichols and Osbury, City of Detroit, County Plain?
yes, I was
And what were you doing in that area?
patrolling.
And while in that area, did you observe anything?
Yes, I did.
And what was that?
While patrolling, I observed a male standing inside of a chicken restaurant, exiting. As he exited, I observed him to have a gun in his pocket. I observed the tight ripped jeans. And you can see the handle sticking out of his pocket.
And is that person in the courtroom today?
He is.
And can you point him out and describe the piece of clothing that he may be wearing?
I can't see his clothing, but he has a black shirt, green writing, and long hair.
Let the record reflect that the officer has identified the defendant.
So reflected.
At that point in time, what did you do?
I attempted to engage and investigate.
And what occurred?
Once he observed me about to investigate, he entered back into the location, closed the security gate, and locked it, and walked behind the cashier counter.
And what did you do at that time?
I disengaged, and I waited across the street for him to exit the location.
And were you alone?
No, I was with another officer,
And his name was,
Officer Jones.
and what did you do? What happened next, I should say?
A few minutes went by, and he then exited the location. When he exited, I observed him to still have the same firearm in his pocket. And he walked across the street to a liquor store.
And what occurred next?
I went over to the liquor store in my scout car, and Mr. Love exited. Upon him exiting, I observed the firearm and intended to conduct an investigation. When I conducted my investigation, he began to walk very fast back to the chicken location. You like me to continue, right?
What happened when you reached the chicken location?
I attempted to make contact when he ran into the back door of the location, closing it very fastly. I exited, intended to go after him. When he went into the location, he went to the left of the location and had come back out. As I went in to get him, he came back out and we met at the door, and I detained him.
After you detained him, what happened?
I asked if he was a CPL holder.
And what was his answer?
No.
What did you do next?
At this time, I got in contact with the owner of the location for consent to search the area.
And was consent obtained?
Yes, it was.
And what occurred when you searched the area or the restaurant?
I did a plain view search, recovering any weapons that were in plain view, which were 2 shotguns, which were both loaded. After recovering those firearms, I then did a more thorough search into the area where I saw Mr. Love go.
Where was that area?
To the left area. As soon as you go into the back door, to the left, which is the grease fryer.
And did you find the weapon?
Yes, I did.
And where was the weapon?
The weapon was under a grease fryer pan.
Which weapon are you referring
It's a black Walther pistol.
to? But not identifying what you're saying you found the weapon, you also mentioned 2 shotguns.
Right, the weapon that I was specifically looking for was the pistol that I observed Mr. Lewis to have. The shotguns were in plain view, which is why they were recovered.
What type, I'm sorry, what type of weapon?
It was a Walther, it was a 22 caliber black pistol.
Was it loaded?
Yes,
And after you recovered the weapon, what did you do?
I informed Mr. Lowe of his arrest. I then entered the firearm into Lee, the serial number of the firearm, and the weapon was placed on evidence.
I have nothing further for this, Mr. Honor.
Morning, officer.
Good morning.
In your investigators report, you indicate that upon successful detention of Mr. Love, you observed that him to no longer have a firearm in his pocket. Is that correct?
That is correct.
Okay, so when you ultimately detained him, he didn't have that firearm on, correct?
Correct.
Okay. And you put it in the back of the police vehicle where you continue your investigation?
That is correct.
Okay. And at that point, once he's detained, you indicate, due to my observation of the firearm, I asked Mr. Love if he was a CPL holder, which you replied he was not.
Correct.
Is that correct? Okay.
Yes.
And then again, that's once he's in the back of the control car, correct?
Correct.
Okay. And how long did it ultimately take you to find the firearm?
Took a little while. I can't give a specific time.
Hour, 2 hours?
Maybe an hour.
Okay. And he wasn't charged with the rifle, was he?
The shotgun. No.
Okay.
The shotguns were taken because there were 3 listed felons inside of the location.
Okay, just to be clear, this was a place of his employment?
Yes.
Okay. And at the time of you detained Mr. Love, you had no knowledge that he had been convicted of a felony or had any criminal history, correct?
Correct.
Okay. And you didn't have any reason to believe, prior to asking him, that he wasn't lawful, that he wasn't in lawful possession of a firearm by having a CPL, correct?
Correct.
And the investigation that you conducted, this was just pertaining to suspicion of CCW offense, correct?
That's correct.
Okay. I have no further questions.
None, Your Honor.
Good morning.
Any other witnesses? Please.
Yes, people call Officer Karen Barron. Officer Aaron. Here. Aaron.
heard, then I'll swear you in. Proceed. Raise your right hand. Swear to tell the truth, nothing but the truth. Make sure you speak up to the microphone. Whenever you're ready.
Thank you, Your Honor. Officer, could you state your name and occupation for the record, please?
Yes, sir. My name is Officer Terrence Barron. I'm currently assigned to the 8th Precinct Detective Unit.
And how long have you been with the police department?
4 years.
And in this, what's your role in this matter?
I was the officer in charge of the case. I was currently assigned to the detective unit.
And were you on duty February 17th this year?
Yes, sir.
And did you have an opportunity to have a discussion with Mr. Love?
Yes, sir.
Is he in, is that person that you had a discussion with in the courtroom today?
Yes, sir.
And could you point out his location and describe his clothing that he may be wearing?
Black t-shirt, it looks like. Is it a t-shirt? Yeah, black t-shirt.
Let the record reflect that the officer identified the defendant. You had heard having a discussion with the defendant. Did you read it? Go over his Miranda rights?
Yes, sir.
And how did you go about doing that?
I usually have the defendants read them aloud to me so I can hear them and make sure they understand it. And then they initial next to each one, and then they do a signature and date and time at the bottom.
And did that occur in this case?
Yes, sir.
And did he, the defendant actually make a statement?
Yes, sir.
What was that statement?
He said that, and this is not verbatim, but he said that he was on probation and conditions of his probation didn't allow him to be in consumption of alcohol. And he had the gun and alcohol when the officers saw him. He got nervous and he ran through the beer and the gun.
So you admitted to having the gun?
Yes, sir.
And they acknowledged, I'll strike that if you already answered. I have no question.
And, Officer, good morning.
Good morning.
If Mr. Love his Miranda rights once he was already detained, correct?
Correct.
Okay, and at that point, that's when he made this. At what point, how long had he been detained? And you asked him to give up his Miranda rights, or read his Miranda rights rather than engage in this investigation.
This was the next day after he was arrested.
Okay.
So this was at the detention center.
Okay. And then, were you on the scene of the incident?
Yes, sir.
And that was the first statement you took from Mr. Love?
Yes, sir. No. So first, are you saying on scene or at the DEC?
That was the first statement that you took from Mr. Love, the statement you took after Mirandizing him the next day?
That's my only statement I took from.
Okay. All right. Thank you. I know.
Can you read it?
No regret.
Okay. Any other witnesses?
No other witnesses, Your Honor.
Any defense witnesses?
No, Judge.
Your Honor, people move to have the defendant bound over on count one, weapons carried concealed, reserve argument.
Judge, Officer Mapson indicated that, based on, allegedly seeing my client with a firearm in his right pocket, that he was detained in the back of a police vehicle, at that time, after being detained in the back of the police vehicle, for several minutes. Officers inquired whether or not Mr. Love had a CPL. He indicated that he didn't have a CPL. The officers had no prior knowledge of my client having a felony or any criminal record. There was in no time did the officers have reasonable suspicion to believe that my client was unlawfully carrying a firearm without being licensed or engaged in any criminal activity until they detained him and asked him. In this case, a seizure did occur prior to the officers becoming aware that my client, who was exiting his place of employment, did not have a CPL. Thus, the officers did not have reasonable suspicion that my client was committing or was about to commit a crime. As such, Judge, the officers violated the Fourth Amendment. The client's right to be free from the illegal search or seizure. Under the people, the United States versus Kyle Floyd, it was a similar instance where the officers saw an individual exiting the liquor store, purchase an inch of extended magazine. Reasonable suspicion requires, I'm reading from the case, that is United States versus Kyle Floyd. Reasonable suspicion requires more than a hunch. As the U.S. Court of Appeals noted in U.S. v. Smith 94594, officers can ask reasonable questions without reasonable suspicion. Further, can position themselves immediately deciding in front of the suspect or even reach across the suspect. In this case, he was already detained, and the employee, the court made the following findings: the seizure did occur prior to the officers becoming aware that the defendant, who was exiting the liquor store, similar to my client, with a purchase in his hands, did not have a CPL. Thus, the officers did not have reasonable suspicion that the defendant was committing or was about to commit a crime. Accordingly, because the officers violated the defendant's Fourth Amendment right to be free from an illegal seizure, the court granted Mr. Floyd's motion to suppress the seizure of the gun and any statements made by the defendant after the arrest. Judge, as the court heard these facts near that of Mr. United States versus Floyd, again, in this case, the police clearly violated my client's fundamental right to be free from unreasonable government interference under the U.S. and Michigan Constitution. There's no dispute in this matter that my client was detained prior to the officers asking him if he was a CPL holder. Again, similar to the facts in Floyd, it was impossible to disregard my client's rights were unequivocally violated. As such, I'm asking that the court dismiss this matter as the search, seizure, and the subsequent questioning were a result of unlawful violation of my client's constitutional rights.
Your Honor, officers are on standard patrol. They see a gentleman with a gun or in his pocket. When they go approach to do a investigation, the defendant avoids him several times before they finally catch up to him. And by this time, he's hidden the gun. By his own admission, he knew he was not supposed to have that weapon. So the probable cause standard, whether his rights, were violated is, a question of fact for the, trier of fact. And we ask this matter to be found over third circuit.
Judge, I would submit that it's a question of law. And the fact is, the only reason that he was detained was due to the suspicion that he had CPL. And pursuant to Floyd, this matter should be dismissed.
We've seen the, weapon that given the officer from.
And the whole point of Floyd is that they had no reasonable suspicion that he wasn't lawfully carrying a firearm with the CPL until after they detained him and questioned him about that. At that time, they didn't know whether or not he had CPL, so it's not considered reasonable suspicion, according to Floyd.
Testimony I have here is that eventually the first officer testified that he met, after going back and forth, leaving the liquor store or the chicken place, leaving the liquor store, the defendant and the officer met at the door and he detained. You all agree with those facts?
Yeah.
And that there was no other fact or any evidence of how long he was detained, how he was detained. You all,
Your Honor, he indicated that he was detained in the back of the police car. And then at that point, that's when he questioned him whether it's
he was
CPL.
CPL.
Yeah.
There was no testimony to how long.
They had searched for, he said, for approximately an hour.
That's correct.
So did you have an opportunity to, you received the brief from Attorney Brown?
I did email it.
Yeah, our officers.
I was going to say that there was a distinguishing fact here from the case in Floyd. But facts show in Floyd that there was an extension magazine sticking out of his pocket. Is that correct? Okay.
Correct.
In this case, we have a handgun sticking out of the defendant's pocket as well. There are facts, evidence on the record that the defendant turned back and went to the store after officer believing that the defendant saw him, and then leaving back out with that same handgun in his pocket, and then going back into the chicken spot and leaving the officer with no gun on him, and after being detained, police car over an hour, was asked if he had CPL, and answered no. I do believe that questions should have been asked before being detained. And violate the Fourth Amendment rights. Simple question should have been asked before he was detained in the car for an hour. So I'm going to dismiss without.
Thank you, Judge. Thank you, Your Honor. With prejudice?
With prejudice. I'm sorry, without prejudice. Without.
Okay. Thank you.
I'm gonna trick you the same way. Okay, we're on the record. This is case number 2356552, people of the state of Michigan versus John Stephen Williams, charged with one count of weapons carrying concealed set for defense appearances.
Edwin Sawaki, P5488, hearing on behalf of the people.
Good morning, Your Honor. Sophia Nelson of Neighborhood Defender Service, P77960, appearing on behalf of John Williams, who is present here in court today behind me. Mr. Williams, please state your name for the record.
Everyone ready to move forward?
Yes, Your Honor.
Yes. Okay, any preliminary matters?
None from the people.
None from the defense.
If there's anyone on YouTube or on Zoom who may be a witness on this case, now's your time to log off. If there's anyone in the courtroom who may testify today, it's also time to leave the courtroom. Mr. Sawaki, you can call your first witness.
Officer Ricky Mathis.
Yeah, see, sir. Officer Mathis. Yes. Still with my court recorder, and give me a minute.
Recorder,
Ricky, R-I-C-K-Y. Mathis, M-A-T-H-I-S. Thank you.
you swear to tell the truth, what we've done?
Yes, sir.
Make sure you speak up in the microphone. Whenever you're ready. Officer.
Thank you. Officer, could you say your name and occupation for the record, please?
Ricky Mathis, I'm a police officer for the city of Detroit
How long have you been with that agency?
for almost 7 years now.
And were you on duty on April 20, I believe it's April 21st this year?
Yes, I was.
I'm sorry, it was April 20th.
Yes, I was.
And were you in the area of Finkel and Rossler, city of Detroit, County, Wayne?
Yes, I was.
And what were you doing in that area?
I was working routine patrol.
What did you observe?
A vehicle that had an expired tag and.
Objection, lack of personal knowledge. Lack of foundation, I mean, can't see that it's expired. Someone ran it through lean, it wasn't him.
We don't necessarily, I don't know that. There are ways to establish expired child without money, to my knowledge, but.
Lack of foundation, so
Can you just
I.
clarify?
I can elaborate.
I'll ask the question. Can you clarify as to how you know that?
How would you know that, sir?
The tag had 0922 on it, and we're in the year 2023.
Okay, and what did you do next?
I then conducted a lien inquiry, which is a law enforcement information network, which then verified in fact that tag was expired in 2022. And the vehicle showed to have no insurance.
So at that point in time, what did you do?
My partner initiated our emergency equipment and conducted a traffic stop.
And after the vehicle stopped, did you approach the vehicle?
Yes, I did.
And what were your observations at that time?
I instructed the occupants of the vehicle to roll the windows down as they were tinted. As they rolled the vehicle down, I observed obviously a driver, a front seat passenger, and 3 individuals in the back seat.
And did you observe anything else?
I did. There was a noticeable odor of burning marijuana emitting from the vehicle. The backseat passenger immediately next to me, as I made a passenger side approach to the side of the vehicle, had a bottle cap, if you will, with burnt ash in it, and where they said they were smoking marijuana driving.
So what did you do at this point?
I asked the front seat passenger to provide identification along with several other occupants within the vehicle.
And did the front seat passenger receive this courtroom today?
Yes, he is.
Would you point him out and describe the piece of clothing that he may be wearing?
He's gonna be the gentleman in the front row, behind the council. He's wearing a gray shirt, long dreads, black male with a beard.
Let the record reflect that the officer has identified the defendant. No reflection. Did he produce any identification?
He produced a Michigan driver's license that contained a picture of a white male.
And did he give an explanation?
When asked, he stated it was his neighbor's. And I asked what the name on the identification card was. He was unable to provide the name. He said he didn't know what the name was.
Did he give you any identification identifying him?
Not at that moment, no.
What did you do next?
I asked the individual to exit the vehicle.
And what happened after? Did he exit the vehicle?
He did.
And what did you do at that point in time?
At that point, with the burning marijuana and the lack of identification in regards to preventing the wrong identification, I conducted a pat down of this person where I subsequently located a handgun that was concealed within his groin area.
What did you do?
I removed the handgun and notified my partner and other scouts or other police officers on scene that he was in fact armed with a weapon. I pulled the weapon out to find it loaded with one live round in the chamber, along with numerous live rounds within a magazine. That individual was handcuffed and detained for further verification if not, he had a concealed pistol license.
And type of weapon?
It was a Smith & Wesson M&P Shield 38 caliber, I believe, or a 380 caliber.
And what happened to the weapon?
We ended up placing it on evidence at the Detroit 11th precinct after I verified through lien that the individual did not possess a concealed pistol license.
And nothing further, witness, Your Honor.
There were 5 individuals in the car,
That's correct.
and the driver provided a license, correct?
That's correct.
And before your partner went to run that license in lien, you asked if there were any weapons in the car, correct?
I would imagine so. I ran the license in lien.
And the occupants of the car responded in the negative, correct?
That's correct.
And then you asked if there were any CPL holders in the car, and the occupants also responded in the negative.
I can't recall exactly, but that would be something along the lines we would ask.
And it was a backseat passenger who informed you that they were smoking, correct?
That's correct.
So you don't know if the driver had been partaking in the smoking, correct?
Correct.
Okay. And then everyone was ordered out of the car,
That's correct.
and they were handcuffed,
That's correct.
they were seized,
Come again?
they were seized at that time,
You mean detained?
detained, seized, yes.
Okay, sure,
They
detained.
were not free to leave.
Correct.
And at that time, you had no reasonable articulated suspicion to believe that any of the occupants of the car were armed and dangerous.
That's incorrect.
What was your reasonable articulated suspicion that someone was armed and dangerous after asking if there were any weapons, getting a no, and not observing any weapons?
The individual kept putting his hands down towards his groin. I instructed him numerous times to keep his hands up. Also, through the use of illegal narcotics while they're driving.
Is
It's
marijuana
illegal.
illegal in the state of Michigan?
If you're driving, it is.
If you-
Smoking marijuana.
If you're the driver,
From my understanding, you can't possess or smoke marijuana in the passenger compartment of the vehicle, whether you're a passenger, similar to the use of open intoxicating alcohol.
so marijuana and tinted windows make you jump to reasonable suspicion that armed and dangerous?
Presenting a identification that I believe is possibly stolen certainly does.
Okay, so a wrong ID and the smell of marijuana makes you think that someone has a gun?
They possibly could reasonably be armed, they are in a commission of a crime.
So after you frisked all the passengers, you proceeded to search the car, correct?
It was my partner did, and then I conducted a secondary search.
And that search included the purses of the female backseat passengers?
That I don't recall.
No further questions. Redirect.
Officer, in your experience as a police officer, is the fact that, identification or license was given to you that was not belonging to the defendant, mean anything to you? They could have been anything?
Yeah, from my experience, it's extremely uncommon to be in possession, in my experience as a police officer or as a person, to be in possession of someone else's identification. I believe it's reasonable to believe that that individual may be in possession of stolen property.
Nothing further, Your Honor.
Thank you, Your Honor. Thank you very much.
Any other witnesses?
No further witnesses, Your Honor. We have people move that the defendant be found over on count one, weapons carrying concealed, reserve argument.
That's assuming no defense.
Oh, I'm sorry.
No defense.
I jumped the gun.
Your Honor, the smell of marijuana by itself does not give rise to probable cause to search a vehicle or order the occupants out of the vehicle. It's a recent Michigan court.
Can you step to the mic, please?
Yes, my apologies.
Sure.
Yep. Smell of marijuana by itself does not give rise to probable cause to search a vehicle or order the occupants out of the vehicle. That's People versus Armstrong, published Court of Appeals decision 2022 Westlaw 1716956. Similarly, in 2009, the United States Supreme Court in Arizona versus Johnson said that just like people on the street, officers require reasonable articulated suspicion that a driver or a passenger is armed and dangerous to justify the frisk of the passenger or the driver. Here, we have an individual, the driver, who's not my client, who certainly can be detained for the purposes of driving without with expired tags or without insurance. We have people who may or may not be smoking marijuana. We have a backseat passenger who says something about that and is in possession of some burnt ash. We have a front seat passenger with no testimony regarding possession or use of marijuana, merely the odor of the marijuana in the car, who's ordered out of the car. That's fine pursuant to MIMS. We need something more to then proceed to search him. He should have just been released from the scene. He's not the driver, and he was not observed smoking marijuana. Instead, he's illegally detained and illegally frisked. There's no reasonable articulated suspicion to say that he's armed and dangerous when we have somebody who says he's not armed and he doesn't have a CPL. You need something more in order to frisk somebody. The frisk was in violation of the Fourth Amendment. He has a reasonable expectation of privacy in his person, and for that reason, the gun should be suppressed in this case should be not brought up.
Your Honor, the defendant gave the officer a false ID. Didn't know who the name was on the false ID is, and claimed that it was the license of his neighbor. If your neighbor leaves his driver's license, you should know his name. That's enough to give probable cause for the search. The officer even testified that he was probably going to be arrested for having a false ID. The fact that they found the gun while doing the search. Not only he had reasonable suspicion, which turned into probable cause to search the defendant. The gun was found on the defendant, and this is a clear case of that should be found over. There's enough probable cause. We ask for a Bible.
Having someone else's ID is not a crime.
It is if it's asked for identification purposes, Your Honor.
So, oh wait.
Can we actually recall the officer, because my understanding is he gave his neighbor's ID and then he gave his ID prior to the frisk. And I'd like to ask the officer questions about that. I mean, unless you're, I think it's an important issue here because if my client did provide his ID, I think that is pretty positive.
This is the one. Your Honor, even then it comes down to his say. It's a question of facts. And we've already argued, I object. We're asking for a find over.
I mean, I don't want to have a suppression hearing in circuit court. If my client provided an accurate identification prior to the frisk, I mean, I don't think even providing the ID provides reasonable articulated suspicion that he's armed and dangerous. So I think regardless, it's an illegal frisk. But if this court's going to rest its head on the providing someone else's identification, I think it's important that we explore that in judicial economy. I ask that there is have a suppression hearing in circuit court.
I'm not gonna open the proofs back up. That's something that should have been asked on cross.
I should have, but my client's not sitting next to me, so he wasn't able to alert me to the issue until after the proofs had closed, otherwise I would have.
Why was it sitting next to you?
Or officers told me to put them there, and I didn't know that I could request them next.
Well, during cross, you have to consult with before cross, you consult with your client, and I'm not gonna open the proofs back up to allow for more testimony based on what was said. You're stating that your client is saying that he did present his own ID as well as.
He's
a
saying
fake
that
ID
he
or someone
accidentally
else's?
gave his neighbor's ID, and then when they said, who is this, he realized he provided the wrong ID, then he provided his proper identification.
I'm not sure if that's what to decide. Mr. Salon? Did you have something you want to say?
No.
Oh. I'm not gonna allow the proof to be real. I don't know why the defendant had someone else's identification. But what the testimony that no one mentioned is that the defendant or the testimony that Officer Mathis observed the defendant kept putting his hand in his pants. So with the presentation of the wrong identification, plus the smell of marijuana in the vehicle and ashes of marijuana, although it was not the defendant who had it in possession, along with the defendant putting his hands in his pants, I do believe that the officer had enough to ask the defendant to step out of the vehicle. And because of the put his hands in his pants to do a pat down, I was in the throwing area. And that's where he found the gun. It's going to be a question of facts for trial fact. So we're going to be bound over to Third Circuit Court for an arraignment on the information date of June 15th at 9:05 a.m. The bond convened.
Hold.